welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about mutual legal assistance. Cases that should have gone to the Supreme Court of Canada, but didn't. Canada and a number of other countries have a treaty in place called the Mutual Legal Assistance Compact. It allows countries that are investigating similar offenses, typically drug offenses, to share information and to request assistance and to have that assistance provided by the police agencies of the other countries. Dexter Boyce was convicted of drug trafficking offenses and drug importation offenses, and at trial the Crown's case relied largely on information that was obtained from Panama through the Mutual Legal Assistance Compact. Mr. Boyce argued at trial that he shouldn't be convicted on the basis of the fact that the Mutual Legal Assistance Compact was unconstitutional. The trial judge and the Court of Appeal exercised their discretion not to decide the constitutional issue, determining that it could have no impact on the outcome of his case. He sought leave to appeal to the Supreme Court of Canada, and they also refused to hear the case and thereby refused to determine the constitutionality of the compact. This case obviously raises significant issues of national importance. Whether or not Canadian law enforcement agencies can basically just phone up another law enforcement agency in another country that might not have the same constitutional obligations as ours in order to get information, documents, evidence that's been obtained potentially illegally according to Canadian law is a huge, important issue. The Canadian government shouldn't just get a free pass on getting information about Canadians in other countries simply because they have a treaty with those other countries. This effectively allows Canadian law enforcement to use information that would otherwise have been obtained in violation of Canadian law. And the Supreme Court of Canada obviously should have taken the opportunity to decide whether this is actually constitutional or whether people have the opportunity to challenge the constitutionality of the searches, seizures, provision of evidence, and provisions of the Mutual Legal Assistance Compact that allow police agencies to share this type of information. By refusing to hear this case, the Supreme Court of Canada missed an important opportunity to clarify a law that comes up very rarely, but has significant impacts on the procedural rights and charter-protected interests of individuals facing charges for only the most serious of criminal offenses. This is absolutely the type of case the Supreme Court of Canada should be hearing, and it's unfortunate that they didn't take this opportunity, which means that people may potentially be convicted of some very serious offenses on the basis of illegally or unlawfully obtained evidence. And that's something that can't be considered to be appropriate in our legal system. We have to have another case that'll give us the opportunity to look at the constitutionality of these provisions of the Mutual Legal Assistance Compact, and hopefully that case will come sooner rather than later. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.